Welcome back, everyone, to the employment space. This channel is designed to bring to you a 360-degree view of the employment relationship. Who is this channel for? It's for employers, employees, independent contractors, vendors, employment attorneys, and HR professionals. Now, in episode 3, I brought to you the 5 things employers should know about the Fair Labor Standards Act. And with that federal employment law, it is known to be the most misunderstood and misapplied in the employment relationship. In episode 4, I brought to you Title VII. And that federal employment law, although it is foundational to this country as being one of the most well-known federal employment laws, it's also one that's the most litigated in the United States. Today, I'm bringing you the Americans with Disabilities Act, also known as the ADA. And this federal employment law, well, it creates the most risk and liability for employers due to failure to follow process. That's why today I'm bringing you the 5 things that employers should know about the ADA. Let's talk about it. Number 1, are you a covered employer under the ADA? Now, the ADA has some similarities to Title VII in terms of confirming whether or not you are a covered employer. Under Title VII, which is episode 4, an employer must meet a specific threshold amount of having 15 employees. Once you've properly classified your workers, and your workers are now then confirmed to be employees, at least 15 employees, and you are indeed covered under Title VII. The same goes for the ADA. Once you have confirmed that you have 15 employees, which means you have met that threshold amount, then you have confirmed that you are also covered under the ADA. Another similarity between the two is that under Title VII, the coverage extends between or throughout the entire employment relationship, if you remember me referencing that. With the ADA, the same applies. That means once you have confirmed coverage, the ADA affords protections to your prospective employees, your current employment relationship, your current employees, as well as former employees. So once coverage is confirmed, just know it is not optional. Moving on to number 2. How do we define disability? Believe me, it's probably broader than you think. The ADA defines disability as a physical or mental impairment that substantially limits one or more major life activity. The ADA provides examples of what a major life activity may be. It can be walking, seeing, jogging, sleeping, concentrating, okay? And many other examples. The thing about it is that I think employers, when they hear that, there's an initial shock. They assume that when it comes to a disability, it's something that will be in the employee's life for the rest of their life. In other words, a disability means something that is permanent. And under the ADA, that's farthest from the truth. The ADA also affords protection and extends protection to employees who are suffering from or have been diagnosed in some way with a temporary disability, something that's some sort of temporary episodic condition, or even a temporary condition or disability that stems from taking medication, okay? So try to, as an employer, I think what's key is to know that the ADA does not require an employer to diagnose an employee or to put on a stethoscope, I always say. That's not the requirement for it. It's really to determine and to work with the employee to determine what is necessary with this disability, whether albeit permanent or temporary or physical or mental, like what's needed in order for the employee to perform their essential functions. So I think the best thing to do when consulting with counsel is to try not to be so narrowly tailored in thinking or making assumptions about what's protected by the ADA, So we're going to move on to number 3, and that is the interactive process. Now, the interactive process is the heartbeat of ADA compliance. And what does that really mean? It means that the interactive process is legally mandated. It is an obligation for the employer. It is a requirement. There is no option for an employer to undergo the interactive process upon receipt of a reasonable accommodation or leave of absence under the ADA that comes in from an employee. It is a requirement. The interactive process should be a healthy dialogue that occurs with good faith. That means the employee shows up to the conversation about what's needed to perform their essential functions in good faith, and the employer appears at the conversation, at the dialogue, in good faith. I look at the interactive process more so as like a tennis match. The employee shows up to the conversation with ADA compliant paperwork from a treating physician and will throw that ball like over the net to the employer for consideration. The employer then considers it in good faith, and if anything is needed in the conversation, there are certain steps to take there, and then we'll hit the ball back over the net to the employee. And it's a tennis match that goes back and forth between the employment relationship until a conclusion is arrived. You know, many things can come up during the interactive process. That's why it must be timely. It must be well documented. And the employer should know that the ADA interactive process is not cookie cutter. It should be unique. It will be unique to every individual employee that requests a reasonable accommodation or leave of absence. Okay, so it's very important because I think this is, from my experience being a former litigator, I could definitely attest to the fact that if an employer is going to have any ADA claims brought against it, it will be because of the failure to properly engage in the interactive process or failure to engage in it at all. Okay, because it's important. In order for you to arrive at the next step, you have to go through the interactive process. Speaking of the next step, number 4 is the reasonable accommodation. In general, employers are required to grant a reasonable accommodation or leave of absence under the ADA. What is not required is for the employer to automatically grant what is preferred by the employee to serve as a reasonable accommodation. What's key when it comes to accommodations is to grant what is necessary for the employee to perform their essential functions on a day-to-day. And I think that's what highlights the necessity of the interactive process, because both the employer and the employee are engaging in this dialogue in order to determine what will it take for you to perform your job. Hence, the interactive process is going to allow for an opportunity of clarity, for deeper discussions, to ask questions, and to iron through some alternatives. So I think the reasonable accommodation process will always get the parties, the employment relationship, to a place where an accommodation can be created if possible. And that's why talking to your counsel about the do's and don'ts during the interactive process and before you arrive at a reasonable accommodation is absolutely necessary. But what is not necessary, I will highlight again, is giving the employee their preferred accommodation. It's all about what will it take for the employee to perform their essential functions. Moving on to number 5, which is retaliation and confidentiality. ADA is a federal employment law that is no different than other federal employment laws when it comes to the fact that it too carries an anti-retaliation statute. In the previous post talking about Title VII, we talked about retaliation, that there's one general rule, and that general rule for retaliation under Title VII, albeit that the ADA is a different law, it also carries the same rule, and that is do not ever retaliate. That means an individual employee that approaches the company for a reasonable accommodation or leave of absence, and let me back up a bit, because the ADA does not only apply to your existing employment relationship. The ADA, again, I'm going to highlight that it applies to the prospective employees, existing employees, and also affords protections to former employees. Okay, so the anti-retaliation rule applies to all phases of the relationship dealing with an employee. Okay, prospective, existing, and former. Okay, when it comes to retaliation claims, I think that there's a misconception. I think that sometimes when companies receive from the EEOC, for example, a charge of discrimination alleging disability discrimination and retaliation, the assumption is that if the disability discrimination charge is defensible, then that must be the same for the retaliation claim. And that's not necessarily true. As a former litigator, I can tell you that many times an employer can have a defensible disability discrimination claim, but the retaliation claim is successful for the employee. It survives. Okay, so I think that it's key to know that these are two different areas, if you will, under the ADA. You have disability discrimination, but you also have to abide by the retaliation statute, which says to not take certain adverse actions against the employee, prospective employee, existing employee, and former employee, because it could amount to or be seen as retaliatory conduct. Now, that doesn't mean that the employer cannot make certain business decisions or other decisions, corrective action decisions, if you will. But before doing that, before any final decisions to take any actions against a prospective employee, existing employee, or former employee, the best thing you should always do is to seek counsel. That is the safest way to make sure that you reduce any risk to the company. Now, when it comes to confidentiality, what's important is that the conversations, documentations, and medical documents, they cannot be handled in the same way that the general personnel file information is handled. So in other words, whatever is maintained in a personnel file or a manager's file, that is not the same way that you handle matters that are brought to the company for ADA reasons. It has to be handled with a certain level of confidentiality. Again, you need to consult your counsel to make sure that how you're maintaining ADA-related records for employees, that the company is absolutely in compliance. We're going to stop here, provided the 5 things employers should know about the Americans with Disabilities Act. And, thinking about the previous post under Title VII, it's amazing how sometimes there are some sort of similarities or things that can help you, focus on what each of them stand for. Like with Title VII, it's about fair process and accountability and employer response. And when it comes to the ADA, it's about process and communication and good faith. So thank you for watching this post. Again, the Employment Space is here to provide you a 360-degree view of the employment relationship. I'm going to be very selective over the information that's on this channel. I'm not just pushing out content to you, but you'll be seeing some interesting things come across. If you have any questions, make sure you reach out to me. My email is in the description box below. Remember to like, share, subscribe, comment. And I'll see you the next time. The next post is on the FMLA. I'm so excited about that. And I know in the previous post I said that this post was going to be about the Equal Pay Act, but actually we're talking about the ADA. The next post will be about the Family and Medical Leave Act, and the post after that will be about the Equal Pay Act. Okay, everyone. Thanks for watching. I'll see you next time. Bye.